There is a prehistory of the commitment to freedom that we find in the Canadian Charter and the First Amendment of the U.S. Constitution. This prehistory is part of the reasoning for our being free countries. The country we live in is a free country fundamentally in that, and that's the sentence I want to finish. It's important to be clear about why and how we are free, because if you cannot make the argument for liberty, you will find yourself being deprived of it by someone else's formulation of your rights. Here's an example of this. Say your freedom of conscience is threatened. You turn to the First Amendment of the U.S. Constitution, which is a brief text. There it is, the whole of it. A brief text without an explanation. This text is not clear in its meaning. You might say it is clear, but James Madison, who drafted it, disagreed. The committee he drafted it for cut out words that Madison said were needed to make this clear. Say you argue that these words are clear and you proceed to spell out the meaning. Well, in doing so, you're going to add words and resolve the ambiguity. So implicitly, you agree with Madison. And a person who does not like the way you have resolved it is going to challenge your reading, and it is a reading, they're not wrong about that. They will give you their interpretation. One way to break out of this your reading versus mine business might be to go back to the source Madison got this from. James Calvin Davis, who edited this anthology of Williams, writes, Roger Williams may not have sat at the table on which the First Amendment was drafted, but his fingerprints are all over the tradition of religious freedom in America. But you will get a distorted understanding of that tradition of religious freedom from sources like the courts. They do not have a proper understanding of the rationale for freedom that Williams offers. Learn that rationale, and for one thing, the sense of the First Amendment will be very clear. Then you can butt heads with those people who will tell you that religious freedom is a highly contestable freedom whose rationale is shrouded in fog. This author writes, one of the most enduring puzzles in political philosophy and constitutional theory is why is religion singled out for preferential treatment? That question is proof that Brian Leiter has not encountered Williams's argument. This book got very positive reviews. Judges and legislators are no better informed, and their rationale for freedom finishes by denying the freedom supported in the Constitution. We have the same problem in Canada, excuse me, but magnified. People think our tradition of freedom goes back to 1982, date of the Charter of Rights and Freedoms. Where does their rationale for freedom come from, do you think? Though initially Williams was rejected, and it is not clear who read him, the Englishman Roger Williams is a major figure in our tradition, American and British, thus Canadian. To a very significant degree, his ideas were those that took hold. You hear them in the thinking of the most articulate advocates of freedom, like Madison. But there are plenty of people today who do not know their own tradition regarding freedom. I'm waking up to this very late in life. If you care about rights, you have to be among the people who can explain them. Thanks to Williams, the rationale for religious freedom and liberty itself is not shrouded in fog. To give you a sense of our progress, this talk will be in 3 parts. I want to look first at the conditions in which violations of freedom of conscience arise. Why does this happen? Then I'll give you Williams's explanation of what liberty is, lay out a principle of liberty that he says puts an end to a conflict that he calls the trampling of conscience. And to become familiar with what this rationale is, we will spend most of our time in this second part. I want you really to learn what Williams's case is. You might wish to hurry to the present-day applications, but that will be weak if we're still hazy on what we are applying. Application will be the final quarter of the talk. We'll simply apply Williams's principles to 4 conflicts of conscience in the present day to see his understanding of how a free country operates. So now to our first topic, which is the nature of the problem itself, the conditions in which violations of conscience occur. With Roger Williams, we're talking about freedom of conscience, not just religious liberty, the first encompassing the second. Conscience has to do with convictions, belief, not simply religious beliefs. In his books, Williams argued against the bloody tenets of persecution, oppression, and violence in the cause and matter of consciences and religion. Madison's original draft of the First Amendment, by the way, contained both terms, not just freedom of religion. Note two things here. The phrase conscience and religion means belief per se and religious belief in particular. Williams is concerned with both. We will look at the issue of acting on the basis of your belief, but just note that the focal issue is belief. Also, Williams is not concerned solely with violence. Persecution is the category. It is a kind of injustice. It can take two forms. Oppression, when a person is burdened on account of his or her beliefs, fined, disadvantaged, mocked. And violence, when actual physical force is used against him. He is whipped, jailed, or worse. So when we are able to say death to nobody, we have not made all the progress we need to make in a free country. Williams writes, persecution for cause of conscience is when a man is punished for professing such doctrines and worship as he believes to be of God. Note here those two features: punishment for an act of belief, professing some doctrine that you believe, or some act of worship equally based on belief. So the necessary ingredients for violation of conscience are power and dissent. A person dissents, does not agree that something is true, something is right, and then does something because of it, acts on the basis of his belief, an action that can be, Williams says, a refusal. But in doing so, this person breaks a law or a rule that was set up precisely to stop this particular action. I add a rule because an ingredient here is power, and this power does not have to be held by the government. It can be the power of a professional organization, which orders doctors to behave according to its standards of professional activity, and holds the power to punish. In the case we are looking at here, however, the law has failed to stop the undesired action, failed to prevent this behavior, and the dissenter is punished. Not for dissent in itself, but for some act that follows from it that has broken the law. Power plays a dual role here: the power to pass a law prohibiting the act, and the power to punish the act when committed, which is all one. There is no law if there are no consequences of breaking it. Thus Williams writes, amongst the crying sins of our own or other sinful nations is violence and oppression for dissenting. I'm sorry about my voice. I just recovering from a flu. Some examples from Williams's day. Puritans in England were called dissenters. The figure at left is labeled a godly dissenting brother, and the figure at right a Presbyterian, while at the back are a Catholic and an Anglican, crying out, "Alas, our design is spoiled," because the two Protestants have chosen to set aside the sword and embrace. Puritans were called dissenters because they rejected the form of worship in the official church, which they believed was anti-Christian, an issue of belief. Anglicanism, they said, encouraged hypocrisy through the use of set prayers in the mandated Book of Common Prayer, was idolatrous in its use of vestments, ceremony, and ritual, and created an anthropomorphic church in its understanding of apostolic succession and the power of bishops. In short, it was effectively worship of the Antichrist, seen here wearing the papal crown. Roger Williams was himself a Puritan with just these views. These Christians wished to purify their worship of all papist elements, and because they dissented in this way, they refused to attend Anglican services, criticized them, and established their own churches, and for these acts they were fined, removed from office, say as a professor of divinity, and jailed. Note the word tenets here, which means beliefs held or tenets. Catholics believed reformers such as Luther to be the mouthpiece of the devil. Catholic priests in Reformation England believed that they were the preservers of Christianity. What can any believer do but exalt the Lord in the manner they believe exalting? So they defied the proclamation of 22nd February 1604, issued by James I, ordering Catholic clergy to leave the kingdom by 19 March, less than a month away. The reason given was that their absolute submission to foreign jurisdiction at their first taking of orders made them less than fully subject to their king's authority and endangered the peace of the realm. In 1604, this is the same issue raised later against Kennedy in 1960. To whom was he loyal? But in James's day, there were foreign Catholic spies keen to topple a non-Catholic king. If any English Catholic priests did leave, many more surely stayed in hiding to feed their flocks, administering the very body and blood of Christ. That was their understanding of what they were doing. As a result, they wound up in jail, tortured like spies to give up the hiding places of others. Writes W.B. Patterson, an increasingly anti-Catholic Parliament demanded a more stringent penal code, including an oath of allegiance in 1606 meant to test the loyalty of those committed to the spiritual authority of the papacy. Understand then that we're talking here about treason. New laws passed to pressure Catholics and identify the treasonous now required citizens to receive communion in the Protestant Anglican Church. Patterson writes, those who refused to come to services could be made to pay £20 a month or lose 2/3 of their property at the king's discretion. Also, anyone who attempted to reconcile any of the king's subjects to the Pope was considered to be guilty of high treason. In 2017, a BBC drama about this period showed the execution of 2 Catholics in London in the manner of the time. It showed it fairly indirectly, but very clearly, and there was outrage. I feel I owe it to the martyr to show you this, just this one glimpse of a young Jesuit executed for simply being in England. Patterson writes, these measures were intended to sap the strength of the Roman Catholic community, even at the expense of making the Eucharist, the sacrament of unity, into a weapon of coercion. This is John Ogilvie, a Scottish Jesuit who went to Scotland to minister to the few remaining Catholics in the Glasgow area after it had become illegal to proselytize there. But Ogilvie was tried for treason. He refused when he was asked to pledge allegiance to King James, whom he accused of playing the renegade from God. Ogilvie said he would acknowledge him no more than an old hat. You see here that he suffered the death of a traitor. By the way, I'm not looking at this to be gruesome, but to show you something curious about this. You are seeing biblical thinking. This method of execution appears to come from the 13th century and is associated with Edward I, Edward the Confessor of Christ, who is a saint in the church. It is a biblical and symbolic method of capital punishment used by Edward on an English nobleman in 1283. Consider the following explanation. For killing English nobles, he was hanged alive. For killing those nobles at Easter, he was eviscerated and his entrails burned. This is surely a reference to Judas, who at Easter hanged himself and, according to Acts, burst open and all his bowels gushed out. For conspiring to kill the king in various parts of the realm, his body was quartered and the parts sent across the country. His head was placed on top of the Tower of London. This is surely related to the murdered concubine in Judges 29, divided and sent throughout the land. I just want to show you that biblical rationales are involved here, the sense that Scripture shows the way to justice. Might we need some qualifying of that idea? And note the symbolism. As a traitor acts to dethrone a ruler, to divide him from his people, the head separated from the body, the traitor's head is separated from his body. And this reminds us that the biblical language of Christ's kingship and the union of head and body is political language. Of course, it is bodily language, but it is clearly understood in the ancient world and in the medieval and early modern period as political. It is a bodily metaphor of the king and his people. There is a clearly seen parallel between Christ and politics. The New Testament uses this political language to set Christ in relation to a king, or an emperor, a governor, a pharaoh. They're all understood as kings, rulers. You notice that the king holds a sword here. It is a sword over his land, his people. And here's why I've gone into this. When we are talking about rights of conscience or religious freedom, we are never talking about just that. We are talking about the right of a citizen against a state, a king, the civil powers. We are talking about the rightful division of jurisdiction, about the medieval doctrine of the two swords. The doctrine of the two swords. The civil power, the king, who is the head, his crown, has physical power over his people, represented by his sword. But there is another king with another crown, who is also a head. But the power of this king, as the king himself explains, is not physical, worldly. Yet it is a sword. It is power. Scripture mentions the double-edged sword. It is a sword of power, the sword of the final judgment. It's mentioned in the book of Revelation relative to the end days, when all Christ has said will be manifest in power. From his mouth comes a sharp sword with which to strike down the nations, and he will rule them with a rod of iron. He will tread the winepress of the fury of the wrath of God the Almighty. Revelation chapter 19. You see this represented here in the early 14th century with a following army, as if the civil power helps to bring that wrath. This is an interpretation. But in the age, in the age before the end time, the idea of the sword of Christ's mouth is his teachings, his call, his request. What do you want me to do for you? These are the instruments of his power over people. And Williams talks about the powerlessness of the civil sword outside its domain. This connects us with a quite ancient idea, which is that, quote, religious freedom rests on a simple truth. Religious faith is an inward disposition of the mind and heart, and for that reason cannot be coerced by external force. This truth was stated for the first time by Tertullian of Carthage, a Christian writer who lived in North Africa in the early 3rd century. Tertullian wrote, It is only just and a privilege inherent in human nature that every person should be able to worship according to his own convictions. The religious practice of one person neither harms nor helps another. It is not part of religion to coerce religious practice, for it is by choice, not coercion, that we should be led to religion. Focus on this last point. Physical force and coercion constitute an unjust intrusion into the domain of religious belief. It will be part of William's message to say that in the Christian world, though people know the difference between the two kings to whom they are in debt, they do not know how their two kingdoms work and where the boundary is between them. Because of the King of Kings, William says, the scope of civil power, even in the hands of a truly Christian king, is strictly limited. Before Locke, Williams is already marking out, and in a more deeply Christian way than Locke will do, the Lockean vision of the limited or liberal state. Why do I call it liberal? In being limited, the state lets things alone. In Williams, this is not simply a political theory. It is a Christian lesson. I'm getting a little ahead of myself here, as before we get to Williams, I wanted to offer some concrete examples of the conflict over conscience that he would address. And we should certainly not skip Williams's own case. Roger Williams in the colony of Massachusetts refused the offer of head of the Boston Church, the colony's main church, claiming it had not denounced the Church of England. And he began to petition for this break. Says Davis, he quickly became a thorn in the side of the Massachusetts leadership. He became known for holding strange opinions. For instance, that the native Narragansett people showed greater character than the English, theft, murder, gluttony, and adultery being largely absent among them. And that the natives were owed payment for the colony's land, which the king was in no position to grant English permission to settle on. He refused the Massachusetts court's order to swear loyalty to the colony, giving reasons that you will soon appreciate. A civil power cannot command a person's conscience. God may command, but then leaves the decision of compliance to each person. And so Williams broke the law and refused to recant any of these positions. As a result, he was to be arrested and put on a ship back to England, which would likely have meant being sent to the Tower. But he was warned and fled his house in the dead of winter, given shelter by his native friends. I had a picture here that's not showing of Williams fleeing through the snow. Philip Harmon is described as one of those visionary enthusiasts among the people called Quakers that pretended to possess lights unknown to the rest of mankind, etc. Apparently, Harmon revived the heresy of Montanism. For this sort of behavior, Quakers were not allowed to enter Massachusetts and Virginia. Some were hanged for doing so. Where Quakers were allowed, they would be fined for absenting themselves from the divine worship in the established church. Yet because Quakers believed that Quakerism was the way of the church and that Christ's call to preach the gospel was a call to them, they broke that law. John Cotton, the chief minister and theologian of the Massachusetts Bay Colony in the 17th century, had warned, by the ancient laws of that unchangeable God that thought it insufferable in ancient days, God thinks it insufferable now, that priests and Jesuits should bring in other altars, other meditations and mediators. The Lord looks at it as deeply meritorious of a bloody death, as in former times. He is the same God, and his zeal and jealousy is deeply provoked against the like kind of viciousness, that is, inclination to vice, now as it ever was then. Let in the Catholics, later the Baptists and Quakers, and viciousness will reign. For the well-being of the colony, government must control them. Four examples of these conditions at work, creating conflict, and of each of these events there are two descriptions. That offered by the ruling power, holding the power to legislate and to punish, and another description offered by the dissenter, just and unjust. The power understands its jurisdiction to be actions, the body, not the soul. It has no rulings against thought. It has laws against doing certain things. It is normal for it to call this protection of the order of society. That is what any ruling power is asked to do. It sees the punishment as justice. But the dissenter calls it injustice, a perversion of justice. So our question will be, whose claim has precedence? Who here is right? How do we resolve this conflict, this complete difference of opinion about justice, and show who is right? Ask each party how this dispute can be resolved, and you will just get all the arguments all over again. One party says, I am duty-bound to worship, to speak my mind, to preach, etc. The other says, we are duty-bound to put a stop to anything that we judge bad for this community. If you think about this, you will find that you can identify with both sides here. As a believer, you have no difficulty identifying with the dissenter who must worship or preach in the way that you consider to be worshiping, to be delivery of the actual good news. Equally, as a believer, you have no difficulty identifying with the figure like Cotton or Madison, who believed that it was their job as men of politics to secure the conditions conducive to the common good of the people of their colony or state. Ask yourself, does it do damage to marriage and conditions of family welfare in a country if you found marriage on felt commitment, as is now set into the meaning of marriage as it is treated in the law? If love equals love, then all such marriages are equal, yes, but also no love equals no marriage. When this love dissolves, so does the marriage. Is it good for society, for social welfare, to understand marriage in this way? Clearly, I think no. So if you have the view that a state or a country should have the ability to define marriage in a way that is conducive to the welfare of its citizens, then you understand the reasoning of Cotton against Williams. A colony has a mandate to control the behavior of its people in the interest of their welfare. This is a very powerful principle. Notice that you have here a right of religion versus a rightful power of governance, a mandate from the king or later from the people to protect the civil order. And this is really our question today. This looks to be a stalemate, broken by the fact that one side holds the power. In other words, looked at in terms of whose right is greater, we can see the case on both sides. Instead, we will settle it in our favor every time. On whichever side of this line we find ourselves, that will be the side with the greater right. But if that is what we do, it's not clear that we're using any principle. We're treating our judgment as the compass. But where is the test that our choice is right? Where the issue is worship, we will worship as our conscience dictates. Where the issue is the commonweal, the common good, we will act or vote to protect the good, again, as our conscience dictates. But locating your position in any given dispute of conscience is not a test. That's just settling it as we would like it settled. We should have a rationale that picks out the right choice. And the rationale we're looking for is one that would be intelligible and persuasive on both sides of the argument. To resolve a conflict is not just to settle it, to give an answer that closes the debate. When marriage was redefined in the law, was that conflict resolved? Were the people left in a state of conviction that, after all, the right thing had been done? No, the state settled the issue, picked its side, favored its argument, and did not resolve the issue. In a free country, we need an argument that closes the conflict in a satisfying way for all sides. What is impressive about Williams is the power of his argument. Who in a dispute of this nature should be supported? What is the principle that shows us this, which is the right way? What does Williams say to this? There's a slight risk of misunderstanding Williams that we want to move away from. Consider this. Do you agree with these lines, which I take from Williams's book, The Bloody Tenet of Persecution? Now, the 17th century diction is always going to hinder a quick grasp of meaning, so I'll try to clarify as needed. Magistrates, as magistrates, have no power of settling up the form of church government, electing church officers, punishing with church censures. But to see, that is, magistrates have no power relative to religion but this, no power but to see that the church does her duty herein, that is, in these areas of her own business. And on the other side, the churches, as churches, have no power, though as members of the Commonwealth, as legislators in the local government, the clergy may have power, no power of erecting or altering forms of civil government, electing of civil officers, inflicting civil punishments, say, on those the church has excommunicated, as by deposing magistrates from their civil authority. And here the reason is being given, as here meaning for the reason that, as by deposing magistrates from their civil authority, stealing the power of the magistrates, no more than to discharge wives or children or servants from due obedience to their husbands, parents, or masters, etc. That is, the argument is this: the power of parents to govern their children belongs to the very nature and role of a parent. And you must respect the proper discharge of that function and not steal from a parent his or her proper power. And you may no more depose a magistrate than depose a parent. In the same way, you must leave the state its power and the church its power, and not give either of these two power over the other. And the last part here is saying, even though civil authorities persecute people for conscience, even when this happens, the rule of law, the right of the legislator to enact laws found to be burdensome, providing these laws are passed in the proper manner, must be accepted, and the cry of persecution not be counted reason for taking up arms against the magistrates. This argument of rightful powers, which is really the argument of subsidiarity, by the way. This is not my opinion. Don't listen to me. Listen to Russell Hittinger, who has made a deep study of subsidiarity and says this: subsidiarity cannot be construed as judgments, decisions, actions at the lowest level. The notion of the lowest level perverts the concept of subsidiarity. The better term is proper level. The lowest level can only mean the individual or perhaps partnerships, which are aggregations of individuals. Subsidiarity, on the other hand, presupposes that there are plural authorities and agents having their proper, not necessarily lowest, duties and rights with regard to the common good. By the way, what's the lowest level of paternal authority? Ask yourself this and you find yourself asking a stupid question. You already know what the answer is because you are substituting in your mind proper rather than lowest. Now, this argument of rightful powers wherein limits are set beyond which powers may not reach, may sound to you like the principle by which we are going to resolve our conflict. This, you may be thinking, is the principle Williams supports. And isn't this the medieval doctrine of the two swords? But this is the view that Williams criticizes. I said I lifted those words from the Bloody Tenant, and I did, but this is a quotation given by Williams, which he took from a document titled The Model of Church and Civil Power, drafted in Boston by Cotton et al., and sent to Salem to keep it in line. What Williams says about this is, of course it is true that powers are properly divided, each with its own jurisdiction. No question about that. The question is, what is the jurisdiction? Where is the boundary between the two powers? Matters to be decided by the conscience, matters to be decided by the state. Here's why Williams is important. A contest over an issue of conscience is ordinarily not resolved because this contest is always seen as the two arguments for and against the action in question going up against each other. What happens? You give your argument, and then the state weighs in with its argument, and the state decides, well, this dynamic is not your tradition of freedom. In the United States, you have the Religious Freedom Restoration Act approved by Congress and signed into law by Bill Clinton, and many states have their own versions of it. This is the act that you are told protects your religious freedom. But what I want to show you is that the way a RFRA case often plays out completely sidelines the rationale for religious freedom that lies behind the First Amendment in the thinking of Madison and earlier Williams. The RFRA debate is a distortion of the tradition of liberty, and here's a person who understands this. I've heard Christian political theorists talk about how Americans can rely on the Religious Freedom Restoration Act. But that is really baffling.
But this is a pretty good example of this. So the Indiana law says, and this is supposed to solve this problem, a governmental entity may substantially burden a person's exercise of religion only if the government entity demonstrates that application of the burden to the person is the furtherance of a compelling government interest and is the least restrictive means of furthering the compelling interest of the government.
So in regular English, that means you can't discriminate against someone's religion unless the government decides it's good for the government to discriminate against someone's religion. Is that right?
That's what they think they can do, and of course that's why there's a lot of unhappiness. You know, I compare...
Douglas Laycock has been called a towering figure in religious liberty, not just because it is the focus of his academic career, but for testifying on these issues before Congress and in the courts. He spoke in defense of Hobby Lobby. About the way RFRA settles these cases, Laycock writes, whenever a RFRA case can be parsed as a case of discrimination, of religious bigotry, a free pass to impose your values on other people, then it will lose. Because, quote, in cases of discrimination, the religious side always loses. So the question we're trying to answer here today is not how can we justify, how can we make arguments to justify our claim to freedom. Go online to look at the Canadian Department of Justice remarks on the section of the Charter on Freedom of Religion. It talks about balancing competing rights. Our oppressor knows what is good about religious freedom and has put that in the balance and weighed it. It does not outweigh what he has put in the balance when he checks the scales. Say the issue is the provision of so-called medical assistance in dying, so-called because dying is something that starts and ends on its own. Say you make the argument, I have moral objections. I have the right to exercise my religion. The moment you do this, someone will very sensibly say, religion? I thought the issue was her right to die with dignity. In the balancing or battle of reasons, all good of conscience is outweighed by the injury done to others by denying them for goods known and enjoyed by you, something that is important to them. Your religious principles count, but other people's needs do not. Framed in this way, rights of conscience practically demand to be overruled. But this is not the way this issue used to be understood. Where it is the good of religious freedom versus the good of these other things, a death I think I can bear, equal treatment, and so on. It is very unlikely that you are going to find anything with which to bulk up your argument and give it sufficient weight in that sort of wrestling match. What I'm saying is that this wrestling match is not our tradition of liberty. This particular contest in which the dissenter has to convince the ruling power that the dissenter's argument is superior or the dissenter's good is simply an historically protected good is not our tradition. In our tradition, we are not split up into parties with different demands that need to be weighed. We are all on one side, the side of the human being served by the state. In Canada, we have a bill in play at the moment calling on Parliament to nullify the decision of the Ontario Court of Appeal last month, May 2019, forcing doctors with conscientious objections to euthanasia, assisted suicide, and abortion to provide effective referrals for these procedures, forcing them. Here we have that same conflict, a law requiring an act, referral, and an act of refusal that the dissenter argues he or she has a right to, refusal to refer. If the way of deciding this contest is simply weighing the goods and benefits of the respective courses of action, forcing doctors to refer, allowing them to abstain, and see which is weightier, what do you think the outcome will be? And that is exactly what is predicted will happen to this bill. My point, however, is that this is not the way of deciding this in the free country that we have. If rights of conscience are ever to be truly and properly granted, we have to break out of this deadlock somehow. And the path was shown to us by Williams, and it is a path that we took. Other principles were set forth by Williams and those who have adopted his thinking. I'm showing you Thomas Jefferson, that suggest a different process than weighing, a different kind of assessment altogether. We're having trouble over conscience, I suggest, because we have forgotten our own tradition. So let's look at that tradition. You will see also that it is not one in which conscience or religion are a trump card. Providing you can claim scruples of conscience, you have a free pass to act. You will see that it has a certain complexity, especially in our day. After he was banished from the Massachusetts Bay Colony in 1635, Williams established a small settlement in present-day Rhode Island that he named Providence. His own experience certainly drove him to think about the issue of liberty. This new colony, for which he returned to England to obtain a charter, officially guaranteed liberty of conscience. Baptists, Quakers, Jews, and other religious dissidents soon found a haven there, so that it was known by the more upstanding in Boston as the latrina of New England. In 2 books and other pamphlets, Williams made his case. In 1644, he published The Bloody Tenet of Persecution, The Bloody Principle for the Cause of Conscience, a polemic addressed to John Cotton, a minister, recall, not the governor, of the Massachusetts Bay Colony that had banished him. When Williams was driven out, Cotton had offered a biblical justification of Williams's treatment. In this book, Williams aimed to correct him. In 1647, Cotton responded with the bloody tenet washed and made white in the blood of the Lamb. to which Williams responded in 1652 with "The bloody tenant yet more bloody by Mr. Cotton's endeavor to wash it white in the blood of the Lamb." In these and other writings, Williams argued not simply about conscience, as you will see, but about the proper understanding of state power. A good, quick way to grasp Williams' position and see what it is opposed to is to look at his exposition of the parable of the tares. Matthew 13 is a text that Cotton had relied upon to justify, biblically, the banishment of Williams. Might this text, read thus, be used to justify all the persecutions I have given examples of? Cotton had explained that the tares are partly hypocrites, like unto the godly, but indeed carnal, as the tares are like to wheat, but are not wheat. Or partly such corrupt doctrines or practices as are indeed unsound, but yet such as come very near the truth, as tares do to the wheat. And so near that good men may be taken with them. And so the persons in whom they grow cannot be rooted out, but good wheat will be rooted out with them. In such a case, Christ calls for peaceable toleration, and not for penal prosecution. Again, notice that Williams is not advocating tolerance against those who say no tolerance. We're not lacking arguments for freedom. Everyone argues for freedom. The burning issue is the nature of the arguments and the reason for the freedom you support. According to this argument by Cotton, who is free? The field in the parable is the church. Those to be tolerated are those who are in the church, who profess the correct faith, but have divergent views. This was Williams earlier on. But, wrote Cotton, if a man hold forth and profess any error or false way with a boisterous and arrogant spirit, Williams clung to his opinions and kept voicing them openly, to the disturbance of civil peace, he may justly be punished according to the quality and measure of the disturbance caused by him. The Christian tolerance taught in the parable of the tares had been extended to Williams. But then Williams ceased to be the kind of person in the church to whom the parable applied. Tolerance had been extended to him, as the parable had advised, but this stubbornness threatened to upset the stability of the colony. At that point, the matter passed into the hands of the civil authorities, and Williams was banished. With these words before us, supporting this reading of the parable, it is easy to leap ahead to the famous cases in 19th century law involving blasphemy. In 1837 in Delaware, a man was fined and given 10 days solitary confinement for saying that two figures of the Holy Family were a whore and a bastard. He lost his appeal, unanimously overruled. According to the court, blasphemy laws were not intended to prevent or restrain the formation of any opinions or the profession of any religious sentiments whatever, but to restrain and punish acts which have a tendency to disturb the public peace. This was exactly Cotton's argument. Acts of blasphemy should be punished so as to put a stop to the negative influence upon others of hearing Christianity diminished and holy figures degraded in this way. Williams said that forcing the blasphemer to shut up would only make things worse. Williams rejected Cotton's reading. I won't give you his argument, well worth reading, but just his conclusions. The field is not the church, but the world, the civil state or commonwealth. The tares cannot signify doctrines or practices, but persons, and not persons in the church, but persons in the world who are anti-Christian idolaters. They worship the Antichrist. That's what that means. Opposite to the good seed of the kingdom. And the ministers or messengers of the Lord Jesus ought to let them alone to live in the world. If you recall that young Jesuit we saw brutally executed, he would be, according to Williams, a terror. Williams thought Catholics were worshippers of the Antichrist, minions of the devil. But what does Williams say is the risk of pulling up the tares? Nothing is risked. It does positive evil. He writes, this permission or suffering of dissenters in the field of the world is not for hurt, does us no harm, but for common good, even for the good of the good wheat, the people of God. It is a good which we can all recognize to let this deluded person live a human life. Williams is not saying the Catholic might turn out to be the one who is right. The good he is talking about has nothing to do with who is right. It is a good for us to have done good, letting the man live. True Christians, Williams is saying, ought to let anti-Christians alone to live in the world, to spout heresy if they are heretics, to blaspheme if they are blasphemers, to set the bad example of never going to church, if such people they are. This behavior is not the business of the civil sword. Williams writes, at the very first blush, no man denies a double ministry. No one says there's only one power. No one says that religion has complete power, that conscience rights trump all objections from the civil power, and no one says that the state has complete power, that state rights trump all objections from conscience. Everyone recognizes that conscience has complete sway in some areas. So the issue is not how many swords there are. There are two. The issue is where the limit on each is drawn. Do you remember our key question? Both sides in a dispute of conscience have an argument. One side says the state cannot punish me, I am out of its reach. The state says, no, you are not beyond state jurisdiction. You are quite within the reach of state laws. Williams is telling us that in a dispute of conscience, both sides, persecuted and persecutor, accept the medieval doctrine of the two swords, but draw the jurisdiction of each differently. Both sides are telling us where the limit is. That is the issue of difference, not whether to be tolerant. So our question is, whose limit is the right limit, and why? Says Cotton, the limit is crossed. Where a line is crossed tells you where the line is. When false doctrines are professed too insistently and loudly, this action is state business. The state, says Cotton, can prohibit such behavior. In her campaign for president, Hillary Clinton thought she would come out in support of religious freedom and wrote an op-ed in which she said, I've been fighting to defend religious freedom for years. We're stronger together when we work in unison to solve our problems, no matter where we come from or how we pray. That last one is important. As Americans, we hold fast to the belief that everyone has the right to worship however he or she sees fit. Well, it was lost on no one that there are no laws against how people pray or worship in the sense she had in mind. As we began by saying, wherever there is an issue of religious freedom, all the laws are about public actions. And Clinton opposed all state versions of the Federal Religious Freedom Restoration Act. Why? Because she thought the laws punishing the Little Sisters of the Poor who opted out of funding contraceptives, Clinton declared herself against the sisters here, were just. She didn't want any religious freedom measures knocking those laws out of action. The state, says Clinton, can prohibit such behavior. And so that you are defending religious freedom of some description tells us nothing. Of course you are. That you draw the line limiting state power somewhere. That you grant God, say, complete jurisdiction over some actions that the law cannot touch. That we can take for granted, whoever you are. that does not mean you are not persecuting someone. The question is, where do you place the boundary of state action? Where may the state not intervene, and why? That is what we need to know. So you appreciate that the Christian principle of tolerance, the doctrine of the two swords, is not enough to grant you freedom. Evidently, it grants you some kind of freedom, but how much? You need another principle to answer that, to determine where the line falls, and this Williams supplies. The dissenter and the reigning power both draw the limit of acceptable behavior somewhere. Our question is, whose line is correct? And our challenge to any participant in this debate is, justify your placement of the boundary between state action and the freedom of the individual. And Williams has just argued that Cotton's limit, you can believe what you want up to the point you act, and then you enter the domain of the state, which will punish what the state calls strident opposition to the church, is biblically indefensible. Williams said that this is not the limit marked by Christ in the parable of the tares. The Massachusetts Bay Colony was trying to preserve its Christianness by Cotton's measures. Well then, he said, it had better follow Christian principles. The doctrine of persecution for cause of conscience is most evidently and lamentably contrary to the doctrine of Christ, the Prince of Peace. Matthew 13 gives us the Christian understanding of the doctrine of the two swords. In Cotton's Christian community, followers of the Antichrist are to be let alone to live in the world, acting as they are inclined to act. The state does not have power over all of their actions. It has power over some of their actions. Two things at this point relative to the 21st century, which is indeed why we are looking at Williams. A great deal of Williams's argument is biblical. And this aspect of his argument is likely to be of real interest to you, but we obviously need to look at William's other arguments because a good exposition of the parable of the tares is going to do nothing in the Supreme Court. But, and here's my point, don't think then that these biblical arguments are not going to help you, because whatever Williams's answer to our question is, some of the opposition to it will be coming from Christians. Trust me, we are seeing this here with Williams and Cotton, two devout believers. Second, we can see right away from this discussion of the parable the weakness of one argument that we are getting today on the acts of Christians. We have to remind people like Hillary Clinton and Clayton Ruby, one of Canada's best-known constitutional lawyers, that it is not our tradition to say that the sphere of religion is belief and the sphere of civil law is acts. In the protracted dispute settled last year in the Supreme Court of Canada against Trinity Western University, which lost, Ruby argued that, quote, the proper place to draw the line in cases like this is generally between belief and conduct. The freedom to hold beliefs is broader than the freedom to act on them. Amazingly, he was quoting the Supreme Court of Canada in 2001. Well, this is not our way of marking the line, the Canadian way, the way of liberal states. It could well be argued that our way has been to follow Williams, who said that actions of the anti-Christian were to be left alone. The liberal approach has been, just as Williams recommended, to reject the habit of curtailing acts, to repudiate the practices of persecuting countries, right? Those countries that persecute. Quote, the Turk, the King of Spain, the Emperor, and the rest of persecutors, while they practice violence to the souls of men and make their swords of steel co-rivals with the two-edged spiritual sword of the Son of God. Wrote Williams, I have impartially pleaded for the freedom of the conscience of the papists themselves, the greatest enemies and persecutors of the saints and truths of Jesus. Even Catholics, writes Williams, are to be let alone to live in the world. Not worship in the world, but live. That is, speak, act, and do as their conscience directs. So here are two claims that are false and display a lack of awareness of the principles we have acted on in our tradition. The Clinton-Ruby view that belief is allowed but actions not is false. And likewise, the opposing view of some believers that all their actions are allowed provided they are matters of conviction. Neither of these views do you see in Williams. Williams argues that there is a point at which the state can rightly step in to stop Christians from acting. But it is not the moment they begin to act as Christians, or act in a way that we do not accept. Where does Williams say the line is drawn? What first is Williams's main objection to persecution based on belief? In part, that it is unchristian, but also that such an understanding of law is dangerously destructive to the very roots of all civil relations, converse and dealing, yea, and any civil being of the world itself. What you see here is that Williams's focus is not the focus we so often have, the securing of any particular freedom. Williams is not focused on undoing the wrong that was done to him when he was driven from his home. He's looking at this broadly in terms of general principle. What Williams is discussing is society itself, what he calls here the civil being of the world itself. That is, how our relations with each other are set up. When do we intervene and punish, and why? If you were to state the objective, if you were to do this, the objective of civil order, what might you say? What you might say is this. You might be inclined to say that it is man's management of good and evil. Williams says that is a bad answer. Civil order is not focused on good and evil. It is focused on human beings, and it is most essentially the proper treatment of those made with a human soul, bearing the imago Dei. Fundamental to the proper functioning of civil society is soul liberty. Room for the soul to live as it was made to do. Conscience, which Williams calls this conscience that is found in all mankind, is not merely that sector within the soul that is conscious of guilt, thus a thing that breaks out on occasion in a pang of conscience. Freedom of conscience is not, as it is so often defined, the freedom to fulfill obligations, especially sacred duties, which flow from an authority higher than the state. That kind of talk is one step away from that second falsehood, the idea of religious carte blanche. Freedom of conscience is the right to run your own soul in the society to which you belong. No mention of that society in the formulation you're looking at, focused as it is on you and your God. Society here is just the scene in which you have this absolute right. Well, that's not our situation. What you see in Williams, I'm saying, is careful attention to the whole issue, which is how men are to behave in society, how laws are to be formed. Thus, we are talking about politics. Conscience in the Middle Ages and the early modern period is the rightful operation of the human soul, given to you to use. The operation of the human soul in thinking as it thinks, fearing as it fears, loving as it loves. Conscience is the operation of the human soul just as it is, made by God and stained by sin. The narrative of the Bible, we should all see, is the story of what happened next. In Genesis, God makes man in his likeness. This was understood by various church fathers as a sharing of divine nature. Man was given the freedom that God possesses, a freedom that man's heart does something with. God makes such a creature, but also makes him or her to be treated as such a creature. This, at any rate, would seem to be the ideal. But in the Old Testament, God himself does not take this perfect approach. He coerces his creature by physical might. And what is the effect? As a way of making men moral. This plan is futile. The Old Testament is the harrowing record of man's use of his freedom, man's choosing, God's efforts to correct man in various ways, ways sometimes demanded by man. Israel wants a king. And the utter chaos of this kind of society, which is not civil order. Anyone appalled by the human chaos displayed in the record of the Hebrews might be inclined to say that man needs the help of religion. And such a person might further say that religion needs the help of the law. And in the combination of these positions, you see the thinking of John Cotta. But this, Williams argued, was effectively to read the Bible without the New Testament. To think in this way was effectively to be an Old Testament type figure, trusting in a hopelessly Old Testament way on an arm of flesh and a sword of steel. The Hebrews had religion and their own laws to boot, Jewish kings. This Old Testament recipe Williams called the natural state, made up of spiritual and civil power, temple and throne, a state exposed as impotent in the Old Testament, not up to the task of aiding man. And Williams contrasts it with man's only true hope, a new Jerusalem from above that is not material and earthly but spiritual. Williams writes, I shall, with the help of Christ Jesus, the true King of Israel, declare and demonstrate how weak and brittle this supposed pillar of marble is, to bear up and sustain such a mighty burden and weight as are laid upon it. God gives man freedom, and any thinking person looking at man, what man does with it, will think that man needs limits, barriers to keep him in line. But Williams is saying that this creates an almost irresistible trap, which is that man rushes in with God, God's laws, Christian morality, not bringing God, who cannot be brung. Whereas what is really needed to assist man is God. Man must respond, must be left alone in his relation with God. But in the same way as nature abhors a vacuum, the fallen man abhors liberty in society. With respect to freedom, then, Williams makes two crucial points. First, that freedom to decide all the issues of life is God's gift to man, and people must be left to wrestle with the choices. Second, that evil of some kinds is exclusively God's business. Is that a principle you have ever heard stated? How much have you heard evil discussed? How often have you heard that said? We want to take care not to distort this second point. The claim is not that God permits evil or overlooks evil, but that what should happen in society with some evil, should it be stopped or diminished? Will it be increased? Is his business, not ours. To be clear about this, we know whether we should blaspheme or skip church. But what should be done about this in the civil law? In answer to this, Williams says nothing. It should be just as you see here, God's concern. It is not our business, except through the exhortation of our lives and words. by no other persecuting than discussing and disputing. Williams writes, "It is the will and command of God since the coming of his Son, a permission of the most paganish, Jewish, Turkish, or anti-Christian consciences and worships be granted to all men in all nations and countries, and they are only to be fought against with that sword which is only in soul matters able to conquer, to wit, the sword of God's Spirit, the Word of God." As I have too much material, I'll leave out this section on Williams' argument for this view of civil order. I wanted to go into this as the reasons matter, but just flying through this. First and foremost is the importance of recognizing the inviolable quality of the soul. Civil laws on matters of conscience are illegitimate. When Williams writes that the government of the civil magistrate extendeth no further than over the bodies and goods of their subjects, not over their souls, he means to say that the state cannot think, deliberate, and judge in your place. It is not a human being. Deliberation is a thing that only a human being can perform. Cotton believed that the state should intervene and dictate the answer, but Williams argues that the soul must not be invaded. It must function as it was made to do. Give men all the arguments. That is how to treat a human being. Any human power that compels you to act according to its belief, its way of answering a question, that it is yours to answer, quote, does violence to the souls of men. This is an injury. Here you have a soulless thing intruding into the soul, a person's most intimate possession, his or hers by nature and definition. Williams called the soul, the conscience, the tenderest part of man. This forcing of conscience is the worst kind of violation. Williams called it soul rape. A soul or spiritual rape is more abominable in God's eye than to force and ravish bodies. That is bad. But this is worse. Second, Williams says that Christians do not persecute. Third, coercion is futile. It does not improve the soul. Can the sword of steel or arm of flesh make men faithful or loyal to God? That is all that matters. Fourth, it does not even serve its civil purpose. A civil sword hardens those compelled by it against their oppressors. Coercion causes civil strife, civil war. Far from preserving civil order, which is the rationale for it, it is against civil order. Plainly, civil order requires avoiding civil war. But Williams notes that there is no better way to foment civil war than by pressuring a person to act against conscience. Williams's first book was burned soon after publication, which tells us simply that at first people did not accept these arguments. But here are the implications of this view in the historical cases we surveyed. And just ask yourself this, isn't what follows from Williams exactly what we do today? The effect of Williams's arguments is to nullify all the civil laws against matters of conscience. In England, Puritans were to attend the Church of England. Whatever good might be done by those laws in bolstering that church, such laws were bad laws for human beings because they intruded into the business that God charged these human beings to settle, really settle in his or her soul. Such a law was a bad law. Catholic priests were to leave the kingdom. This was a desire of James I and others that should never have become law. Catholic priests, if they were tares, should be left alone to live, that is, to lead their own flocks, and to be judged by their true judge. The claim of Protestant authorities that Catholicism was anti-Christian, as Williams himself believed, was simply one more urging of conscience to be assessed with fear and trembling, Williams says. The judgment on that judgment would come, but it is not a human judgment. The laws sending Catholics into hiding were bad laws. In Williams's own case, to challenge the heads of the Massachusetts Bay Colony over these very issues was the rightful exercise of his soul and conscience. And if it seeded doubts about the legitimacy of the authority in that colony, passing laws that Williams argued were illegitimate, this disturbance would be a natural consequence of the free operation of conscience. The soul is burdened with the task of establishing justice. The banishment should never have taken place. Likewise, the other laws. Quakers must be free to enter Massachusetts and free to preach, even against participation in militias. Their claim to such a right was part of their claim to be and be treated as a human being, while the argument against their freedom was an argument to accept the state as the exponent of a human judgment. But, says Williams, the civil magistrate is but the eyes and hands and instruments of the people. And the people have many different verdicts. Think about that. The idea of the state as the exponent of a particular view. Well, if the civil magistrate is but the eyes and hands and instruments of the people have many different views. The state only one. The state then ceases to be the representative of the people and becomes the voice of some people. And in this, it becomes perverted. Whatever the benefits might be of shutting blasphemers up, and there will be benefits, the steps taken to achieve it violate respect for fellow citizens. You cannot do evil to get good. For a time, Williams was ignored. In this book, David Sahat nicely documents, in effect, the history of the support for Cotton's idea, which he took from Calvin, that the civil state must judge the thinking of citizens to the end of preserving the church. Davis writes, Calvin could easily have endorsed Cotton's assertion that the flourishing of religion is the flourishing of the civil state, and the decay of religion is the decay and ruin of the civil state. What is the idea of the myth of American religious freedom? It is really that, in this book, that the ideas of Williams is not even mentioned in the book, by the way, but Madison is, were for a very long time resisted. The First Amendment of the U.S. Constitution was not interpreted as supporting a view like the view we have just seen. But eventually it is Williams's outlook that has prevailed. Whether people know what his arguments are or not, the liberty he argued for in the dropping of all those bad laws came to define our countries as free. So let's now try to wrap this up. What is the implication in our time for the view that Williams set out? At this point, we need to return to the question we have asked. What is Williams's answer to our question, which was, in the event of these conflicts, each side claiming justification and driven by conscience, each side driven by conscience, writes Williams, he that kills and he that's killed, they both cry out that it is for God and conscience. Whose claim is right? Whose line, marking the limit of civil power, is the right line? By now you appreciate that the question of conscience rights is actually the question, where may we use the civil sword? To this, Williams answers, in a free country, excuse me, to this, Williams answers, in a free country, the law will stay away from your conscience. It will not be in your way. But I really must add, it will not be in your way on an issue of conscience, because, says Williams, it will be in your way on other issues. What are these other issues? Notice then that we do not yet have the full picture of the scope of rights of conscience, looking only at conscience, as we have done so far. You cannot determine what legitimate laws are from what we have said so far. We've been talking about a domain free of law. But you cannot see where conscience ends until you map the territory of legitimate civil laws. This is the evil that is human business. Here is Williams on legitimate civil laws. In the civil state, from the beginning of the world, God has armed fathers, masters, the head of a workshop, and magistrates to punish evildoers. That is, fathers, masters, magistrates are to judge and accordingly to punish such sinners as transgress against the good and peace of their civil state, that is, families, towns, cities, or kingdoms. Their states, governments, governors, laws, punishments, and weapons being all of a civil nature. Therefore, neither disobedience to parents or magistrates, nor murder, nor quarreling, uncleanness, nor lasciviousness, stealing, nor extortion, none of that kind ought to be let alone, either in lesser or greater families, towns, cities, kingdoms, but seasonably to be suppressed, as may best conduce to the public safety. At this point, in line with what we have outlined so far, comes a but. Right? But I conclude that there are sinners of another nature, idolaters, false worshippers, anti-Christians, who without discouragement to true Christians must be let alone and permitted in the world to grow and fill up the measure of their sins after the image of him that hath sown them, until the great harvest shall make the difference. Him that hath sown them, these sins, is a reference to the parable of the tares. But while his men were sleeping, his enemy came and sowed weeds among the wheat, the sowing and the growth of these weeds being a thing that God allows. A person may seasonably be suppressed for murder and theft and lasciviousness, but to suppress a person, jail them, fine them, beat, exile, or kill them for blasphemy, for worshiping the Antichrist, for preaching a false gospel, in short, for anything that it is the proper work of an individual to wrestle with and decide, is unseasonable, improper. The terrain of civil laws, Williams is saying, is marked by agreement within society about certain basics. Now, if you were to ask, what is the difference between Cotton's fundamentals and Williams's basics, that would be a very apt question. Cotton said that we cannot have dissent over fundamental beliefs. The state must step in to ensure agreement about basic morality. But notice that he implies we do have dissent, and we must put a stop to this. We have differing views for the state to correct. Williams is talking about beliefs so basic that we are all agreed on them. There is no dissent. It is the domain of the common good. Don't fill this with your own understanding of the common good. It is not the universal good. The idea of the common good is those goods that the people of a given state call good and want upheld by the state. Here then is Williams's answer to our question about the limit of the civil law. We may use the civil sword to protect the common good. Again, it would seem to be important to stop to explain what Williams means by the common good, and I lack the time to do that. So again, here are some statements without support, which I would support if I had time, and you will see that this is not peripheral. The people decide the goods to be protected by the civil law. This is not a region of dissent, difference of opinion. Whether they are Protestants or Catholics or Jews or Muslims, all citizens are fully agreed on the centrality of these goods. This is the set of goods that have that support. Because of that agreement, the forceful protection of these goods is just. In the world, however, there are other peoples who recognize a different set of goods as basic and essential to their society. Williams certainly had in mind the Narragansett with whom he had lived. Finally, the forceful protection of these goods outside our community in theirs would be unjust. That would be an imposition of our values on others. Everything is in place now to see what is going on in our day, to see what Williams would likely say and what we should say if we were to follow his lead. Williams wrote his books when people were drawn and quartered and publicly flogged for their beliefs. We are at no such risk. We might lose our jobs or lose some friends, lose our property. Despite such a difference, the essence of violation of conscience remains what it was. Figures in power are trying to prevent us from doing what we believe we ought to do. The issue then as now is the passing of laws and the framing of rules, both of which are illegitimate regarding matters of conscience. The state has enacted two kinds of law: laws against acts of dissent, having to do with matters of judgment, and laws against acts of disruption, which would cost people benefits that the society calls central, the common good. These laws were both drawn up to put a stop to acts of these kinds and to punish those acts when committed. Williams argued that laws against acts of dissent were illegitimate, injurious intrusions by the state into the business of the citizen that were also dangerous. Every society ought to leave matters of judgment entirely to the citizen and not settle these matters in the law. Thus, a state should not be an Anglican or a Catholic or even a Christian state in the sense of a state with laws requiring Anglican, Catholic, Christian behavior that, if broken by unbelievers, would punish them. Such laws would vanish from the books. Dissent was entirely legitimate, smiled upon by the state, which is conceived for human beings. The only kind of law that would remain was the civil law, over which there was a consensus. These were the laws of the people, laws against acts that everyone in the society had freely recognized as bad for the society. This understanding of law is, in fact, our system. Let me quote constitutional law scholar Michael McConnell. In the liberal tradition, the government's role is to protect the right of the people to pursue their own understanding of the truth within the limits of the common good. The common good as we have just seen it, accepted by the people. That is the difference between the full and free exercise of religion, Madison's formulation, and mere toleration. Toleration presupposes a dominant group with a particular opinion about religion say that it is false, or at least unwarranted. Religious issues have no bearing on what is right. Religious freedom does not proceed from any official presuppositions about religious truth. It allows everyone, believers and unbelievers alike, the right to form their own convictions about transcendent reality and to live in accordance with them. With this clear, let's move now to the application of this to our time. If we truly adopted Williams's plan, there would be no path to punishment simply by way of matters of judgment. On matters of conscience, the state will abstain from taking a position because this is the free business of the citizen. There are no official presuppositions about religious truth. The colony of Rhode Island, the United States, and Canada are not materialist states, and they are not Christian states. They are liberal states, by this understanding of the liberal tradition. anything that a person might conclude, burdened as he or she is with the need to reach answers to questions of this kind. The need to answer these questions. For instance, to be pro or contra with regard to the claim, there is a God who created us male and female. What do you make of that? Or we are stardust and nothing more. Or Narragansett beliefs. In every phase of life, we need the help of the spirit, Manitouhu, who stands to each phase of our lives, 4 phases, like the thumb to each finger. Or the Pope is Antichrist. Or Satan is our Lord and Master, and so on. Each of these is a thing that you may be inclined to make up your mind about, and that you are free to believe, and as McConnell puts it, to live in accordance with. You may act on these beliefs and trigger no punishment, because this is your country where you are free. You are at home here. That is, you are entirely free up to a point, and then the civil law steps in to block you. If by your act of conscience you have done something to disrupt the civic order that you yourself believe in, then you have broken the civil law, and you have no pass of conscience allowing you to do that. What justifiably limits your religious freedom? Take this case. To cause the death of an infant is a crime. This act is punishable for whatever reason it is caused. The cause might have been negligence, but the cause might have been religion. Williams mentions a case in Ireland in which a man felt himself called to a test of faith. God told him to sacrifice his son, like Abraham. But when he undertook this, no angel put a stop to the proceedings. And writes Williams, the man burned his child in imitation of Abraham. Such an act is wrong. The man was rightly punished. The proper barrier on your conscience is all the goods upheld in your civil laws. If an act of conscience tramples such goods, then this act is criminal. Contemporary case number 1. Imagine that it is 1969 and, driven by conscience, as a compassionate doctor, you help bring about the death of an infant, soon to be born. If it is established in your civil law that an unborn child is to be treated just as this born child, then you have broken the law, and this assault on a good recognized in your law deserves to be punished. The civil sword, Williams tells us, has been called down on this compassionate doctor. But if in your law you find no equivalence between born and unborn infants, indeed you find a hesitation in the law to equate them. And that, by the way, is the state of Canadian law, which contains a 400-year-old definition of human being drafted in 1879, adopted in 1892, based on language that goes back to Williams's day, 1642. Section 223(1) of our criminal code reads, a child becomes a human being within the meaning of this act when it has completely proceeded in a living state from the body of its mother, whether or not A, it has breathed, B, it has an independent circulation, or C, the navel string is severed. This is our law today. As a member of Parliament said a few years ago, for me, and I think most Canadians, this law clearly misrepresents the facts. It's based on limited 17th century medical knowledge. That might be, or could it be based on some other old reluctance to equate the unborn with the born, and then take on the lawsuits that equation would bring? But either way, this member of Parliament said there was an injustice in the law. Laws are changed for exactly such reasons. And here's the thing. If in your law you find this hesitation to equate born and unborn infants, then you must change your law before you can punish that act of killing the unborn. The civil law of Canada does not clearly condemn the act of the doctor who performs the abortion. It is not punishable by the state until there is a law. It is punishable rather by God alone. If you wish to see this stopped, you must appeal to the understanding and convince people of why it is wrong. This is what the principle of liberty, as Williams sees it, dictates. Because God, sharing his image with man, gives man the power of judgment to govern himself, all man's actions must be allowed by the state up to the point that they violate the civil laws, understood as that limited but agreed upon set of laws concerned with basic welfare. Outside those limited and basic and unambiguous prohibitions, any issue of deeper deliberation, any question that must be decided by a human being, must be decided by that human being, informed as he or she may be by the arguments applicable here. And that decision, whatever it may be, must go unpunished by us. But note what the principle announces and what it does not say. The principle is not any matter that might be decided by a human being must be left open to the individual to decide as he or she sees fit and not be decided by the state. And all actions flowing from that judgment must be permitted. You hear this second formulation in former Justice Anthony Kennedy's famous statement, which he made in a U.S. Supreme Court decision. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. Kennedy is talking about liberty, and he is indeed reiterating the central freedom that Williams is proclaiming. Kennedy is correct that beliefs about certain matters are for you to form, and the state cannot, and this is the logical cannot, not the moral cannot, answer them for you. If the answer to any question were imposed on you by the state, that would be a fundamental injury to what you are. And that cannot be the nature of the relation of government to citizen. All of that is Williams. But Kennedy is distorting this insight because if you say, as he does, what you see on the right, then you are undermining the civil law. Russell Hittinger gets right to the point on Kennedy's mystery clause. This particular right, the right to decide any matter that could be defined differently by another person's conscience, without further qualification, would give citizens an immunity, from virtually all positive law. A further qualification not given by Kennedy is needed, and this is exactly what Williams supplied. What is missing from the principle on the right is this. A person is not free to define his own concept of murder or theft or fraud. The civil law contains decisions that have been decided for you by a society which has asserted in the law its sense that killing an innocent human being is wrong. It may be that your society needs to clarify some remaining ambiguities. Why does an unborn person have a different legal status? But if that has been clarified, what you may not do is say, I have a right to disagree. I think abortion is fine. And so this state law denies me my rights of conscience, my freedom to choose. It doesn't if it is a proper civil law. If this is a just and established civil law, your conscience is not being trampled by the state in this ban. What is interesting about this recent story, Arkansas Senate passes abortion ban if decision is left to states, is the question of what a state is allowed. Williams would say that the people of a state can set their own laws And to do that, those people have to use some understanding of the world. What is a human being? What singles out the creature to whom our laws apply? And he said that the civil laws protect a common good, by which he meant a good accepted by all the people. The civil laws are not controversial laws. I'm not sure you can create controversial laws. So my guess would be that Williams would find the Arkansas situation somewhat troubling. Something in the scenario he stands up for is missing here. The conditions for a proper civil law are missing. Case number 2. Why is there hesitation about the status of unborn human beings? Why is it not a fact settled in the law, that born and unborn, you are a protected person? But the fact is that it is not settled in the law. It is that kind of world. Just as once it was a world in which an unwanted born infant could be left outside the city gates to be eaten by wolves. But why is there any doubt about the personhood of an unborn infant? Let's say that the answer that you get to this question is there is no societal consensus as to the answer. Well then, it sounds like this is a matter of deliberation. It's a thing that people disagree over. Now suppose you and I believe that people who don't see the equality of the unborn are simply wrong. They're just refusing to see the self-evident truth. Well, now we're making the argument made by Cotton. The facts are staring them in the face, and they are sinfully resisting, simply in order to get what they want. Cotton argued for a civil law to force them to do the thing that they would do if they had the right beliefs. But Williams said no. If this is, right, this is hypothetical, if this is a matter of conscience, you're told people are not agreed, this is a matter of conscience. If it is, then it is a matter of good and evil that is in God's hands. The truth is clear to us, and the dissenter is wrong, just as for Williams, the truth about Catholic idolatry was clear to him, and the Catholic was wrong. But Cotton's view is very common among Christians. Richard John Newhouse wrote, Catholic teachers used to say that error has no rights. The difficulty is that errors are attached to persons, and persons do have rights. Only persons can, by their own free decision, detach themselves from their errors. So, if the reason there is no civil law protecting the unborn is, as you are told, that the status of a fetus is a matter of moral deliberation, a matter of conscience, then it will follow that this person's judgment has to be respected. But if that is so, then your belief that the fetus is a genuine human being, thus deserving of all our legal protections, and you can make an excellent case for that, is no less an act of conscience, also a judgment that no civil laws may touch. And notice the consequence. No state law can demand that you refer. No law may touch your conscience-driven act of refusal to participate in any way in a practice that you consider and have the right to consider killing the innocent, an act antithetical to your understanding of medicine, to boot. If this is a matter of conscience, there can be no law against conscience. But if you are now told that there is a law against depriving patients of legal medical services, let's imagine that such a law exists. What's the tactic here? It is to grant you that there is no law against your conscience, but to point out that you are nevertheless violating a proper civil law. If you are, right? If you are, Williams would agree that you should be punished for doing so. But think about it. If you are now told that you are breaking a civil law, trampling a commonly recognized good, But that's what a civil law analysis is based around. What is that good? What is the good that such a law protects? It is that the people set up to deliver a social service should do it. Police should police, truckers should truck, doctors should promote health, etc. But, and note this, it was just acknowledged by your critic that you are within your rights to believe that abortion is not advancing health. That was the judgment that the law could not touch. Notice what follows. Therefore, you are not withholding the good in that law. How are you withholding a societal good, the good of medicine, promoting health, if you believe, as is your acknowledged right, that abortion withholds the good of medicine? Your opponent granted you that right. If your opponent argues that the societal benefits of access to services that they have no objection to outweigh your right to refuse referrals, this is simply Cotton's argument, that conscience must be overruled for the benefit of society. Therefore, refusing to refer for abortion, or refusing to assist in killing someone who wants to die, or refusing to end a person's life because they are very ill, are matters of conscience, against which it will be very difficult to pass the civil laws of a free country. Case number 3. A person believes that heterosexuality is natural, the plan of nature, and homosexuality is unnatural and a disorder of nature. This person may hold this simply as a view of nature. They do not believe in God and have reached this judgment in, say, an Aristotelian way. And you can do that. A person with such a view would be quite comfortable with societal rules that demonstrate a preference for the more normal and natural condition of heterosexual orientation. For example, a societal rule that restricts civil marriage benefits to heterosexual couples without extending similar societal affirmation to gay couples. This is not a religious view. Religious liberty provides no defense for it, but Williams is not arguing for religious liberty. He is arguing for rights of conscience. This view is this person's understanding of the order of reality. The government cannot have a view of the order of reality, except insofar as bits and pieces of such a view are latent in its civil laws. These being, Williams says, laws that all the citizens accept in common. The state is committed to two things, recall McConnell: to protect the goods implicit in these civil laws, being matters over which the citizenry are entirely agreed, and to protect the right of each citizen to live in the world that he or she believes in. This appears to be a view that the state has no business correcting. How should the state treat this view? And we could also ask, how should the state treat the alternative view held by many that, quote, homosexuality is a healthy and normal manifestation of human sexuality? Michael McConnell gives an answer to both questions, perfectly in line with Williams, when he writes, quote, the starting point would be to extend respect to both sides in the conflict of opinion, to treat both the view that homosexuality is healthy and the view that homosexuality is unnatural and immoral as conscientious positions worthy of respect, much as we treat both atheism and faith as worthy of respect. In using the term respect, I do not mean agreement. Rather, I mean the civil toleration we extend to fellow human beings even when we disagree with their views. We should recognize that the civil magistrate is no more competent a judge of the truth about human sexuality than about religion. What would the effect of this be? The government would not punish sexual acts by consenting gay individuals On the other hand, the government would also not attempt to project this posture of moral neutrality into the private sphere, and would not use its power over public schools to propagate opinion one way or the other, but would self-consciously leave the business of opinion formation to the private sphere. This approach would provide the basis for civic peace on an issue where the nation is dangerously divided. End quote. Michael McConnell. Case 4, last case. A Christian university plans to open a law school. This same university asks its students to indicate their acceptance of sexual abstinence while enrolled. That is, to abide by the biblical understanding that sex is reserved for marriage between one man and one woman, Genesis 2:24. These Christian administrators take their understanding of these issues straight from that text and the Christian tradition. Whether to accept this understanding of sex or not, being a matter of conscience, the school's freedom to have such a policy seems granted. But there's also the other question. Does this requirement of admission break any civil laws? Clayton Ruby, we saw, said it does. In Canada, he said, we have laws against discriminatory acts, and gay students who rejected that understanding of sex would effectively be barred from attending the school. Now, Williams, I believe, would say that the school, which is a power, should not have such a rule. Whether students accept biblical sexuality or not is a spiritual matter that you cannot control by signing agreements. To have such a requirement in the first place is really to put this matter under the civil sword. Not the laws of the state, but the laws of the school. And this, he said, tends to promote hypocrisy. So hypocritical heterosexual Christians would be accepted, but not students who identify as gay, thus openly rejecting biblical sexuality. And Williams would say this is not a good arrangement. Spiritual matters should not be bolstered with the illusory human supports of rules. They should be left under the spiritual sword. But ignore that aside. And look at Ruby's and the Supreme Court's argument. Is this act to maintain a sexual moral code prohibited in Williams's eyes because it breaks a civil law against discrimination? There is actually no law on the books dedicated to equality that would mark this school's behavior as illegal. It is no implication of our existing equality laws that every school should adopt policies that open it to every student, or that religious requirements are impermissible. But because of the Charter, our Bill of Rights, a judge can always turn to its general and vague talk about equality and find this civil law that this school breaks. But the civil laws that Williams said would block some acts of conscience were specific laws whose meaning and application we had agreed on. We have in our current system, with things like penumbras, a defect, the problem of underspecified rights, signaled by Hittinger. He quotes philosopher Simone Weil, who said, "To set up as a standard of public morality a notion which can neither be defined nor conceived is to open the door to every kind of tyranny." If all our civil laws were of the sort that William was referring to, laws against theft, define property, say exactly what must not be done, then this action would not be outlawed. The way the principle of liberty as understood by Williams operates is really quite clear. It's not established by some secret judgment within the soul of a judge. It advances a truly rational and equitable egalitarianism. But I want to leave you with one thought. This understanding of the conditions of liberty does make clear a problem that we face. If our countries are free countries along these lines, why do we have persecution of conscience? A part of the reason is what has befallen the common good. Something has happened that Williams likely never foresaw, that the founders of our free countries did not foresee. And that is the systematic and growing rejection throughout the modern period of the outlook that framed our civil laws. Williams says, "It is not reasonable to force civil laws on strangers, enemies, rebels to that city that has them. That is, to force the laws of the Massachusetts Bay Colony on the neighboring Narragansett tribes would be unjust." But imagine this scenario. Suppose Narragansetts gradually settled in Providence, and as their numbers increased, changed the laws to serve the understanding of good common among the Narragansett, but not accepted by the settlers, and then began to punish the colonists for all the behavior that violated these new civil laws. Williams did not foresee the modern division of society, the split into two cultures set on cultivating antithetical views of the good. Williams undoubtedly thought that the minimalistic region of civil law was settled among us. Did he ever imagine that the citizens of New England would cease to condemn lasciviousness? Providence, Rhode Island, the city he founded when he fled persecution, was just rated one of the top 10 post-Christian cities in America. I doubt this would surprise him. Williams already believed that citizens of New England were followers of Satan and did all kinds of evil. Writes Davis, Williams despised the Quakers' theology, thought the Catholic Church served the Antichrist, and assumed with his Puritan colleagues that many of the Native American religious rituals were devil worship. And he further thought the citizens of Providence should be allowed to do so, up to the point that their behavior broke the civil laws written around the good commonly accepted by the people of his colony. The problem of persecution that is occurring in our day is in this way different from that in Williams' day. But Williams explains it and also shows the way forward. The problem today is in part that society has split, and the inherited civil laws designed to advance the good once common to the people are being changed to advance a rival understanding, as people have a will and a right to do, Williams would say. A rival understanding of the good developed in reaction to and in rejection of the tradition. His diagnosis of our ills. Williams shows that injustice will be created if the common good ceases to be commonly held throughout the society. If two distinct cultures yank the same civil law back and forth between them, each to suit itself at the expense of the other, conditions of persecution become permanent. His remedy. What Williams shows us is the primacy. This is the thing of first importance, of achieving a society respectful of others, of the differences, respectful of the differences that God has permitted to arise. This involves as open a society as possible, accepting of falsehood, leaving difference of opinion and difference of lifestyle as unmolested as we can, while on the other hand, necessarily having civil laws on which the people agree. The usual human solution to that problem is on view in Williams's own life. Twice he separated for the sake of liberty. How this could be achieved when these two societies are as intermingled as they are in our countries is very unclear. But if both do not have the freedom to set their own civil laws, we will be inescapably locked in a zero-sum battle to claim all of Canada or all of America for one culture. That is a prospect of permanent civil strife, in which violence to the souls of men is everyday business, a strange prospect for the future of free countries. I thank you for your extraordinary perseverance and patience.